There's perhaps nothing more important for the real estate agent to understand than the law of agency when working with buyers, sellers, lessors, and lessees. The idea of agency can be one of the most confusing concepts in real estate. To help us untangle this concept is Kadee Wright, Chief Investigator, and Mark Fagergren, Director of Licensing and Education from the Utah Division of Real Estate. Hello to both of you, and thank you for joining us.
Hi, Gary.
Thanks for having us.
Mark, give us an idea. What does the term agency stand for? What does it mean?
Agency, in its kind of technical terms, are the principal who, or in our instance, is your client, is referred to as the principal, and they engage an individual who in real estate is a licensee for the right to represent them in one of the most important transactions of their lives, real estate transactions. So that's a special situation of trust and empowerment where a licensee is representing the interests of someone else and the client is giving over their own personal interests to their agent to represent them in that transaction.
Well, based on that definition, it seems to be a relatively simple concept, although I know it's not. Give us an idea, what is the purpose of the agency law or law of agency?
It's important that the clients are informed of the relationship and of the duties of the licensee and of their individual duties. It's important that they be knowledgeable and informed of the duties of the obligations they're about to enter into, the potential risks, the consequences of this transaction. So they need to be informed and educated and knowledgeable about this process, and they rely to a large extent on their agent to do that.
And why is agency so important to the real estate agent to understand the concepts and principles behind the law?
Gary, I think at the beginning you talked about how complicated it is, and I really don't believe it is. It boils down to being an agent with fiduciary duties is the foundation of the relationship. Mm-hmm. Sometimes a licensee feels like they are an expert in determining market valuation, for example.
Yes.
Or they may be an excellent negotiator, and that is one of their strengths. Or another might feel like I'm great at drafting and preparing contracts that are binding and gets the job done. Still others feel like their ability to find the ideal property that meets their client's needs sets them apart. All of those things are true, but I would add that their agency and fiduciary duties is the foundation upon which they're hired, and it's the reason that they're compensated well for the duties. Mm-hmm. It's not just because they can draft contracts or do these tasks, but rather they're acting in behalf of their client and using all of their skills and talents are demonstrated to put forward someone else's interests above their own even. And so I think it's required that our licensees enter into a contractual agreement. So you can't just have a verbal understanding. Licensees in Utah are required to create an agency agreement with the client, the buyer, seller, lessor, lessee.
And it has to be in writing, correct?
And it has to be in writing, and it has to be performed before they execute their binding contract to purchase or lease a property. Mm-hmm. We encourage that be done early in the transaction so the client is fully aware and informed of the role of the licensee and the duties and obligations of both parties. Mm-hmm. So it is the foundation to have this agency agreement, and then that agreement is confirmed in the purchase contract or in the lease. Mm-hmm. Or in another document executed at the same time of the REPC or the lease. So first they create agency in a written contract, and then they confirm it in the purchase agreement or lease.
Kadee, as the chief investigator, can you add anything to that? You probably see this from a little different lens.
I do, and we receive complaints from the clients and the consumers out there that they had no idea what the agent was going to do for them, how much it was going to cost them. So I think it's critical for the clients to have a thorough understanding of the agency agreement as well as the licensees. And also, if the client knows what to expect, knows how much it's going to cost them to have this representation, then there's no surprises for anyone, and it just raises the professional level for the industry, I think.
Of course. So let me understand this right. You receive complaints from the principal, perhaps the seller, for example, that they don't understand the relationship or the potential services or the fees, even though they've signed an agreement.
Sometimes.
You still hear that. Interesting.
Yeah. I mean, sometimes we get calls saying, well, we closed on our house and we paid them this many $1,000s, and they're shocked at that amount, first of all. And in those cases, there was an agency established, right? Like they had no idea it was going to cost a 6% or however much it cost them. So I think it's critical for the licensees to explain this well to their clients.
Of course, indeed. Well, that sort of leads us to another question, and it seems that the concept of agency is an ongoing problem, or at least a challenge for the division. Why is it something that seems to be somewhat simplistic, at least to define it, ends up being so complicated?
Well, my response to that would be the fiduciary duties, which we'll spend more time, I think, discussing. But when there's a breakdown in compliance with those fiduciary duties, that oftentimes to lead to an investigation with Kadee. So it isn't just disputes over money or the fact that they made so much money, but rather they forget, or it's at least purported, that the licensee loses their focus and no longer is performing their duties and to the manner in which they should in behalf of their client. I don't think agency is a problem for the division. I think it's an area of focus because there's so many. This is where, when there are breakdowns, it's typically due to these agency-related issues. The division has, I'm going to list some of the things we do to talk about agency. We do annual caravans to 8 to 10 locations throughout the state, and agency is an important focus of those caravan presentations.
How do you? So these are discussion points or presentations?
They're presentations by Director Jonathan Stewart, by myself, and Kadee Wright, where we talk about these challenges in each of our respective areas of focus. I'm in licensing and education, Kadee in enforcement, and Director Stewart overseeing the division. So we go to these caravans, and agency is always a point of emphasis for each of the three of us. We also do an annual instructor development workshop. So we train and talk with our instructors about areas that we're seeing where there are problems, and to help them in training of licensees throughout the state. Director Stewart has numerous speaking engagements with the associations and industry representatives, and Kadee and I, to a lesser extent, also go and speak to these organizations. We have quarterly newsletters that we talk about, among other things. Agency is a common theme that is emphasizing its importance. Every real estate licensee has to take 120 hours of pre-license education, as you're well aware, as I'm sitting here in your educational facility. And of that 120 hours, a good portion of that deals with Utah law and about agency and its importance. Then again, those who move on to become a broker, they take 120 hours again of additional education, where agency on a higher level is discussed with those individuals. There's a 12-hour new agent course, and agency is emphasized there. There are over 20 core topic courses on agency. So rather than it being a problem, agency is something that we note is troubling when clients are dissatisfied with the actions of their agent in a transaction. But it's a point of emphasis because we think of its importance and significance in having your clients be long-term clients. So that's our hope and expectation, that if they properly educate and inform their clients and then live up to their fiduciary duties, they'll have long-term clients who will more than meet their compensation obligation, but they have above and beyond served these people and become friends and mentors for a lifetime.
Yes. It sounds easier perhaps than what it is, but Kadee, from your perspective, is this a matter of being a better communicator, the licensee being a better communicator with the principal?
Yes, for sure. And the reason why the division spends so much time focusing on this in our education is because it's still agency violations are still one of the most common violations with the division. So I think it's an ongoing challenge for the licensees and the brokerages for not obtaining those in advance, thoroughly explaining them to their client, and then living up to those duties that are outlined.
What are the basic types of agency? Can you divide them into categories?
Well, I don't think it's that complicated. There's buyer agency or seller agency, which is pretty clear.
Sure.
Or lessor and lessee agency, where you represent exclusively the interests of those parties. And then there is limited agency, and limited agency is allowed under Utah administrative rules. And administrative limited agency narrows the scope of those fiduciary duties. There are 6 primary fiduciary duties, which I'll discuss at some point in our conversation today. And half of those are eliminated when you become a limited agent. So,
is there another definition or another term for limited agency?
In other parts of the country, it's often called dual agency.
Okay.
But our administrative rules call it out as limited.
Limited.
But in most instances, they're synonymous terms.
Okay. And can you explain that a little further? On limited agency, who does the agent represent?
Well, in limited agency, they give up that exclusive representation of a single client. And there's really a couple forms I'd like to talk about. The first one would be where a broker is a limited agent, the broker of the company, and one agent working for that broker represents the buyer, and another agent within that same company represent the seller. And they try to achieve their individual client's best interest, but the broker is acting in a limited agency capacity. That's one form of limited agency. Another one, and it's riskier by its nature, is where a licensee working in behalf of their broker represents both parties simultaneously, which is it's like walking a tightrope. It's very risky.
It sounds like it.
And potentially dangerous. Because, first of all, they started off exclusively representing a client, either a buyer or a seller or lessor or lessee, and now they're saying, I no longer am representing you exclusively. I now am recommending I'm going to be neutral. Yet they have a lot of knowledge about that client, where they've discussed their needs, their desires, their goals in this transaction, and it's hard for them to unload all of that information they know. And then for the other, sometimes it's easy for an agent to put their hand on the scale, so to speak, to benefit one party or the other. And I think legally attorneys salivate, so to speak, when they have a case where somebody's acted as a limited agent, because it's so difficult and challenging. And if either party feels damaged in the contract or in the transaction, you're very well exposed. You have a giant target you paint on yourself if you want to do it. It's totally allowed and legal, but it takes a very skilled person to be that kind of a disinterested third party, and so those are the There's specific agency for a buyer, seller, lessor, lessee, or limited in the capacities I've mentioned.
Kadee, how is limited agency created? Is there a formal process, or do we just say, yep, I'll represent both of you and I'll be fair?
There's a formal process, and there is an additional contract to sign with the agency
That
agreement.
both parties.
Yes, it's a
agree to.
disclosure
Okay.
basically that discloses that they're limited and that they're a limited agent, and there are limitations to their representation.
Well, Mark mentioned that not all states have limited or dual agency. What was the motivation for Utah to perhaps be a little more understanding or flexible in this regard?
I would just say it gives an agent an opportunity, choices, and we're all for allowing people to make decisions
Sure.
and choices, but there are risks
makes sense.
associated with it. One thing that the state of Utah is not is some states have what is referred to as a transactional agent, where they're not representing either party. They're just performing a transaction, like when you purchase an automobile or a refrigerator.
Yes.
And we just don't have that. Every licensee in a Utah real estate transaction is required to have agency agreements, which I've mentioned, and they have fiduciary duties that are tied to every transaction.
And let me add too to the limited agency situation, where licensees find themselves in violation quite often, is being a principal and a limited agent, which is prohibited by Utah law.
Mm-hmm. Although I think we've covered this, can you just review for us again, who are the parties to agency?
The principal would be the client,
Okay.
the seller or buyer, lessor or lessee, and the agent is actually the broker, even though their term is a broker, but the agents that work for the broker are actually sub-agents of that broker. So the agent is the broker, the sub-agents are the people that work and are affiliated with that broker, and then the principal is the client.
I think you indicated earlier that agency is a written agreement, has to be in writing, or it doesn't exist. So the follow-up question to that, I guess, would be, how do you terminate agency?
Well, hopefully and generally it would be by the successful culmination of a transaction after you work with a client, and it may take weeks or months to do that, and they're bought their dream property and they're satisfied, and the agent feels great satisfaction in having represented them well. After that transaction is closed, they no longer have an agency relationship. They still are clients,
So it's just
so to
a
speak.
successful completion of the transaction.
That's one way. Another
Okay.
way is just the contract is for a specific period of time. So if you're
Okay.
representing a buyer, seller, lessor, lessee, you typically do that for a period of time, 3 months, 6 months, a year, and that time can run out and that agreement would lapse. Another lesser used option is the broker or agent can technically release a listing or a buyer from a contract, and they can do that. It's really not at the discretion of the sales agent. It's really ultimately the determination of the broker if, in fact, they want to terminate that
Sure.
agreement.
And it's the broker because in reality, they're the agent.
Correct.
And the salesperson, the licensee, is known as the subagent.
Yeah, the agreement
In
is
most
really
cases.
between the principal, the client, and the broker, and the agent in the office, even though the client may never have met the broker. The affiliated agent goes out to the home and meets with them or the buyer, and they may not meet the broker, but the agreement is actually between the broker or the brokerage
Okay.
and the client.
Kadee, any thoughts?
Yeah, we at the division we get quite a few calls regarding or inquiries about how to cancel their contract with the brokerage, And our standard answer is, that broker is not obligated to release you from the contract, and that's something you'd have to work out with them. Maybe
So the calls are coming from the principal,
the clients,
the seller, or
Yes.
the lessee, as the case may be.
Yeah, asking how can we get out of this? And it's usually because their agent's non-responsive, or their mailbox is full and they can't get a hold of them, so they want out of the contract. They want better service.
Sure.
And those brokers are not obligated to release them, and that's something they'd have to work out with that brokerage.
Here's a really hard question for you.
Great.
What are the
Thanks a lot, Jerry.
What are the fiduciary duties associated with agency? In other words, as we enter into this agreement as a licensee, are there specific identified duties that if we violated, all of a sudden we'd be talking to Kadee about?
Unfortunately, yes. Too often, licensees believe this is a fundamental to pass their real estate or their broker's exam. But this, as I've mentioned earlier, is the foundation of this relationship of agency are these fiduciary duties. The first duty is that of loyalty, that the licensee places the client's interests as supreme and even above their own personal interests. So they might present an offer on a weekend when they would prefer to be at a child's softball game.
Sure.
They have a duty to do everything in their power to represent as though it was themselves making that transaction. They're to promote and protect their client's interests. The second one is that of obedience. So if the client indicates that their home is not to have a key box, or certain expectations that they have, whatever they may be, the real estate agent is to obey and abide by their instructions. Now, if a seller or if a client says, I'm not going to do such and such, but the agent feels like that may deter them in achieving their overall goal, they have every right and they have every expectation to try and advise and provide information to their client. If an agent feels like their home is overpriced and that they will do a disservice to themselves, they have a duty to try and persuade, but ultimately they have to abide by and be obedient to the instructions of their client.
Those things seem pretty logical and realistic.
You think so, but sometimes when that breaks down or their client feels like they're not doing that, that's the rub in the deal, is when they
see that.
lose their focus.
Kadee, is there one basic cause for litigation or lawsuits between clients, principals, and agents? Is there one overriding reason for that?
It seems like the brokers and the agents are drawn into the civil suits, usually over some contractual issue, right?
So agency, in other words.
Agency.
Just a violation of their agency requirements.
Yes. And then also another thing that's common is the compensation or some funds, mismanagement of funds or the compensation.
Sure.
So
money will always do it.
Right.
Indeed. Mark, can an agent appoint another agent to act on their behalf? I think you've referenced that earlier, but just kind of clarify that for us.
Can we circle back to that? But I only covered 2 of the critical 6 fiduciary duties.
My apologies.
And I would be amiss.
Of course.
Because the agent has a duty to do all of these in every transaction. So talked about loyalty and obedience.
Yes.
So another moment or 2, full disclosure is a duty of an agent, that they have to fully disclose to their client anything that could have any potential material fact in this transaction needs to be shared with their client. They shouldn't hold anything back. Anything that could help them make a decision or to know the motivations of their potential buyer in their transaction, they should reveal that. Anything that the agent knows about the other party should be revealed to their client. Anything that about this transaction that has any merit, they should convey that. The fourth one is that of confidentiality. So when they learn from their client, their lips are sealed, so to speak. In World War II times, they talked about loose lips sink ships.
Indeed.
Well, similarly, an agent has a duty to not, even though they associate with fellow agents on a regular basis and have friendships, they need to realize and recognize that they are, number one, representing the client and should not share information that was deemed to be confidential. Anything that would weaken the principal's bargaining position should be avoided. Now, an agent does have a duty to reveal any defect in the property or their client's inability to perform on the contract. If they were aware of that, they have a duty to reveal that to the other agent. But confidentiality is the fourth. I'll hurry up. Reasonable care and skill. I think a lot of Kadee's enforcement cases deal with ambiguous or vague contracts. Or we also see instances where agents want to be Perry Mason and they think that they know more and they want to have. I remember as an investigator one time, I had a licensee had a 2-page addendum that he wanted to be used on every transaction of certain points that he felt were critical, and he was sanctioned for not using a state-approved form because he was essentially modified the form.
So he was acting as an attorney.
He was acting as an attorney.
Which is outside the scope of his responsibility and his license authority, correct?
Absolutely. And he also wasn't doing things at the direction of his client. He was saying, I'll tell you what you need to know and do.
Sure.
And yes, they need to advise, but so reasonable care and diligence is the fifth, and then holding safe and accounting for money. So those are the 6: loyalty, obedience, full disclosure, confidentiality, reasonable care and diligence, and holding safe money. Or the 7th is anything else your client and you agree to in the scope of your services in your contracts.
Well, they all seem reasonable and not too difficult to comply with. Now, back to our question, can an agent appoint another agent to act on their behalf?
That's a question. I don't know if you're talking about like over a weekend situation where they're going out of town, or if we're talking about, hey, take over. Ultimately, I would think that the broker or a branch broker should be delegating or assigning duties to another affiliated agent.
Not agent to agent. In most cases.
If it's, if an agent's going to be gone over the weekend and they say, can you take calls?
Sure.
I don't know that necessarily the broker needs involvement if it's within the same brokerage.
Makes sense. All right. Well, we're up against the clock. We only have time for a couple more questions. Well, first of all, who enforces agency?
My answer to that would be, first of all, statutes and rules call out what is required.
Okay.
So the division has a duty to enforce those, but it's the statutes and rules. So the legislature, it's also the associations, the professional organizations, they have a standards that they want people to achieve. And then ultimately the legal system. If things break down, those are all individuals or organizations that can be involved in that.
That makes sense. Kadee, any thoughts?
No, I think you covered them all. Yeah.
So in essence, we're all responsible.
Well, and the broker, I would add the broker should be enforcing those because the contracts are with them. Okay.
And one last question. Any advice for licensees regarding agency?
I want to remind the agents that they need to always place the best interests of their client above their interests. And
Good advice.
that's a pretty common violation, is the breach of fiduciary duty of loyalty. So as long as they're putting their client first, then I think they'll be safe.
And they may not have to come in and talk to you. Huh?
Right.
Okay. Mark, any closing words?
I would say agency should be created and spoken of with your client and developed into a contractual relationship early on in the transaction, not waiting until you're ready to write an offer,
Sure.
but tell them what you do and live up to your fiduciary duties and actually exceed their expectation. If you do those things, then you're never going to have to worry about Kadee giving you a phone call. You're going to have happy customers that are selling you and your performance to everybody they can
Indeed.
run in contact with.
Well, that's great advice. Well, that's today's show. A special thanks to our guests, Kadee Wright, Chief Investigator, and Mark Fagergren, Director of Licensing and Education from the Utah Division of Real Estate. That concludes this episode of Stringham Real Estate Edge. Today's program was brought to you by Stringham Schools, educating real estate professionals since 1989. Visit stringhamschools.com to learn more. We want to thank today's guests, and don't forget to tell us what you think in the comments section below. I'm Gary Barnes, and I'll see you on the next episode of Stringham Real Estate Edge.